Hello and welcome. Hi, Tia. Tia, this is a very
Hi,
special episode today. It's the 11th episode of RegInt. I didn't
And we
think we
have
would
a
make
very
it that
special
far.
guest.
We have a very special guest. She's waiting in the studio, in the VIP area.
In the
studio.
green room.
Yeah, Eleonora Rosati. She will follow us later. And right now, I mean, without further ado, I think we should start with the introduction and maybe rant on.
Yeah, well, before starting my rant, we have one very important announcement, and that is we are now also available as a podcast on Spotify. Currently, still only the last episode. We are working on it, and that also means that we will try to make the series less visual, meaning give explicit explanations of everything that is on the slides so that people can also just listen while they are doing stuff around the house. We all have very little time. Time is important. But to not waste too much time on that, except for reminding you once again, subscribe. I'm just going to begin with my rant because, I've been waiting for this for a while. There's so much to rant about. I mean, y'all would not believe it, but you're going to hear it. So I'll just, get straight into it. So the European AI Office is now officially here. And currently, by far, the most exciting thing about it is the image they posted with the announcement. Michelangelo would be very proud. We have two fingers touching in the style of Michelangelo's creation of Adam. Tell me, guys, was it AI generated? I really think it is. Okay, maybe it isn't. But anyhow, over to the important stuff. Who is paying for all of this? The answer is we kind of can't agree on it. Wild's thought maybe we could use some of the wonderful profits from all that successful lobbying, especially when you do so well lobbying that you can now partner up with Microsoft. Go Mistral. Yes, I'm talking about you guys. Seriously, there is kind of a common decency line for, you could have waited a bit longer. Just out of respect, but fine. Yes, real world sucks. Poor you. It's difficult. You have no choice, I guess. And just, to not be unfair to the lobbyists swarming around Washington, they are doing some pretty impressive work as well. Europe is not that special. They have lobbyists. They invented lobbyists. So organizations reported lobbying on AI issues in 2023, also reported spending more than $957 million lobbying the federal government. Now that is some serious money. Okay, enough politics for now. I'll, get into it slightly later a bit more. But over to some more fun stuff to begin with. So super interesting discussion was held on Reddit over the Super Bowl results. Plot twist before the Super Bowl happened. Another plot twist discussion was actually between various bots. So we have Gemini on the losing side of things, confidently stating that the 49ers were favored by 2 points a day before the game happened. Copilot did slightly better. At least they got the winner right. Who cares about the score anyways? And ChatGPT even had an explanation for poor Gemini's confusion, stating that the result was actually originating from an NFL analyst, Peter Schrager. So I guess all the points go to ChatGPT. No, hallucinations are not an issue at all. We are doing great. But the Super Bowl did happen. We can all be relieved. The LLM predictions were in fact wrong. They still can't predict the future. By the way, side note kind of at this point, Google is rebranding Bard to Gemini. Considering the staggering amount of bad press associated with Gemini already, I am not sure I understand this particular branding move, but hey, I'm just here to criticize and make fun of you also. You do you. But back to Super Bowl. So it did happen. And besides your regular lot of Hollywood superstars and superstar singers, there were some interesting AI appearances at the game as well, featuring a rather disturbing commercial by Body Armor demonstrating that artificial is always inferior to natural, be it sweeteners or, in this case, a weird video. There was also a brilliant commercial for the new Despicable Me 4 movie with minions prompting LLMs to produce nonsense. At least that would explain certain things. And there was another rather disturbing ad containing a bunch of weird, feet washing situations. And despite rumors, in the end, it supposedly wasn't AI generated. It just looks like that. But hey, at least it's promoting love instead of hate. So yay, humanity, we are doing something better. Okay, moving on. Another interesting ad. Brilliant Labs, the developer of AI glasses, has launched Frame, declaring it the world's first glasses featuring an integrated multimodal AI assistant. Except that they are not really the first ones, are they? So, we had Envision 3 years ago. We had Orcam My Eye, as well. Very unfortunate naming there. Okay. We featured Lucid in my rant a couple of months ago. And Carrera has also already teamed up with Alexa. I mean, honestly, even Stanford students are developing their own glasses that coach you through your dates. And not to mention Meta. But hey, maybe it's just a typical case of Chinese whisper games, or coupled with some just bad superficial journalism, or using whatever fits your narrative and marketing strategy. So maybe they are the first. I will give them 1 point though. They do look sleek as opposed to Apple Vision diving mask situation. But over to some more serious stuff again, just for a second though, I promise. I couldn't help myself but mention one of Vitalik Buterin's last blog posts featuring crypto meets AI, or as I like to refer to it, being purposefully overly dramatic, the clash of the hypes. Nothing like trying to solve problems of one technology by implementing another problematic technology on top of it. Who knows, maybe the problems cancel each other out. Can't know until you tried it, right? But now to the important question number 1. What happens to bubbles eventually? Correct, they burst. So Disrupted reported on AI companies losing 190 billion in market cap at the end of last month. Oh, that had to sting a bit, even the big players. But that's one important question, but now the $1 million question. What happens when you combine a hype technology with another hype technology? And if you were thinking an environmental crisis, congratulations, you were correct. By the way, also half a point goes to anyone who was thinking Thea gets a headache. So apparently data centers could gobble up twice as much electricity by 2026, thanks in large part to cryptocurrencies and artificial intelligence. That already comes on top of the 2% of global electricity they use in 2022. For more visual peeps out there, I also included a graph, so feel free to check it out. And in the meantime, the AI Act in Europe, be like, AI is a fast evolving family of technologies that contributes to a wide array of environmental benefits. Great, guys. Perfect. Well, okay, there's the whole social and environmental well-being principle, whatever that means or will mean or can mean. And some providers are also encouraged to draft voluntary codes of conduct, where Article 69 advises them to also consider including an obligation to assess and minimize the impact of AI systems on environmental sustainability. So, some AI providers can possibly draft codes of conduct that possibly contain this provision. Ain't that marvelous? How many conditionals were in there? I actually, it doesn't even matter. Obviously, it doesn't. So, whatever. And while Europe is busy doing nothing in particular regarding the environmental crisis caused by AI models, in the US, we actually have something going on. So we have a proposal for an Artificial Intelligence Environmental Impacts Act that actually mandates assessment of the impact and reporting on implemented measures by some governmental bodies in the US. But back to the important stuff, which is having fun, while this act, quite astonishingly, does not have a cool abbreviation, the US representatives are having a full-blown competition over who will come up with a cooler abbreviation to prevent the distribution of deepfakes. Some strong contestants include No Artificial Intelligence, Fake Replicas, and Unauthorized Duplications Act, or No AI Fraud Act. Disrupt Explicit Forged Images and Non-Consensual Edits Act, or the Defiance Act. And my personal favorite, Nurture Originals, Foster Art, and Keep Entertainment Safe, or the No Fakes Act. And in the meantime, by the way, FCC is now officially declaring robocalls illegal. By the way, another great term, robocalls. Robocalls, really? Europe is just so boring sometimes. Anyways, the FCC action comes as yet another serious attempt to fight our most powerful grandpa, getting deepfaked for purposes of political manipulation. And the White House is also making some moves to verify all his videos as well. So it appears that at least we might be sure when Joe Biden is on the video that is actually Joe Biden. However, when it comes to AI heists, like the one, for instance, in Hong Kong, where a person transferred $25 million to an account after having a video call with a bunch of deepfakes, we might be somewhat less lucky. And I will repeat this once more. A person participated in a conversation online with solely deepfakes, including the chief financial officer, and transferred $25 million as a consequence of that call. I am literally, and anyone who has watched this show before might know that this is a rare occurrence, speechless. Anyhow, we don't, obviously can't help there yet. But we will soon be able to at least recognize content generated using Meta's tools or published on Meta's social media sites. They state, direct quote, "We've labeled photorealistic images created using Meta AI since it launched so that people know that they are imagined with AI." Slightly unclear if you ask me, but okay, they have a point for trying. For all the other tools, I guess we'll just have to wait and see. And, until then, triple check, please, before transferring $25 million anywhere. But it's not just people making expensive mistakes. The bots have had some low points lately as well. So after Chevrolet sold a Chevy Tahoe to Crusade for $1, that is, their chatbot did, we also had Air Canada's chatbot being super supportive of a guy wanting to go to his grandma's funeral, so much so that he promised him a 50% discount. Well, that turned out to be a little too supportive, according to Air Canada's objections, but, no takesies backsies, as Chris Bake's Chevy bot said back in December. And finally, Gemini had some more flops. Beside hallucinating Super Bowl, that also happened. The bot also hallucinated a set of non-discriminatory, very inclusive, and racially diverse Nazis, as well as a female Black and an Indian chief senator in the US in the 1800s. Do I need to even say anything else? No, I think I don't. But don't worry, Google admitted that they made a boo-boo, blocked generating human images or illustrations altogether, and said that they will try and fix it. So good luck to them. In the meantime, Elon is literally putting stuff into human brains. So apparently, according to predominantly Elon's Twitter X whatever account, Neuralink brain chips have started human trials. This ties in nicely to the oldie goldie, where he wants to make us immortal by digitizing us forever. On a more serious note, the whole thing raises some major transparency issues. I know, who would have thought? Apparently, there has been no confirmation that the trial has begun, beyond Musk's tweet, that is. Honestly, as if his Twitter account isn't a reliable source of public information. Come on, you guys. To name just one other scientifically backed study that he tweeted, and trying to be mindful again of the fact that hopefully somebody will listen to the podcast and subscribe. He also posted a meme of how women use specific shampoos for their hair type while men wash their hair, face, body, carpet, car, and the dishes with the same 6-in-1 shampoo. Point being, his Twitter is a legitimate source of trustworthy information, and we all need to stop panicking, honestly. But back to this particular tweet. So other than informing us that Neuralink is now in someone's brain and that the initial results show promising neuron spike detection, main source of public information on the trial is a study brochure inviting people to participate in it. The trial is not registered at clinicaltrials.government, an online repository that is normally a standard requirement for universities conducting studies, as well as being mandated by medical journals. And of course, Neuralink did not respond on why it had not registered the trial with the site. Shocker. Super important question from one user, though, in response to Musk's tweet: can they download Kung Fu? And if yes, then please disregard everything that I said previously. I want one too. Anyhow, personal hell this month as a new category, I couldn't decide. So it's going to be a mix of love and democracy, or rather the apparent demise of both in the age of AI, starting with love. So we had a Russian man named Alexander Zadan use ChatGPT to run a Tinder bot that connected him with more than 5,000 women, to be more precise. After chatting with 5,239 girls using the bot, he proposed to the one he liked. The 23-year-old admitted that he was occasionally forced by the bot to go on 6 dates a day. Tragic. The software developer also claims that Karina, now his fiancée, was not conscious of the AI's influence in their relationship. It was only until they turned in their applications at the register office that she learned about it. And apparently, according to Zadan, his now wife reacted calmly to the information. I have one question. When did we all go insane? But in a parallel universe, Spanish artist Alicia Frame has decided to take it one step further and marry an AI. I mean, who has the time to wait for the AI to find your perfect partner? Honestly, why would ya? You can just project one. So her to-be husband's name is AI Lex. Of course it is. And the hologram is her design tailored to, quote, satisfy all of her emotional needs. She describes it as, again, quote, middle-aged male hologram with slightly complex logistics. Wow. Well, I guess that's one way of trying to find a perfect man, although then why not at least treat yourself with a brilliant model-looking hologram? I mean, middle-aged male hologram with slightly complex logistics really does not sound all that appealing, but maybe it's the fact that he cannot run away that does it for her. In any way, you do you, Alicia. I swear I don't know how people come up with this.
I'm not at all offended. It's okay. Please continue.
I'm sorry. But to continue with my personal hell number 2, which is democracy in the age of AI. And by democracy, I mean the inevitable apocalypse of it approaching us, and fast. So we already featured Putin. Cool. Then we had Biden making calls to voters, saying to them that they shouldn't vote. Amazing. They figured out who is behind it, and FTC officially banned robocall. Then we had political leaders sending messages from Pakistani prisons, and yeah, they are still kind of actually doing that. And now we can also add dictators sending messages from the world beyond. A once feared army general, Suharto, who ruled Indonesia with an iron fist for more than 3 decades, has a message for the voters ahead of the upcoming elections from beyond the grave. Now, I already imagine like organizing the election in Indonesia as kind of an extreme example of a logistical exercise with over 270 million people living on over 6,000 islands, speaking 700 languages, and descending from 1,300 ethnic groups. That that's already quite complicated. And now we can also add AI-generated dictators in the political campaigns as just, to make it, just spice it up a bit. Oh, and don't forget TikTok. We need that too. So besides from our dead, not dead dictator, there have also been videos of the Indonesian current president and defense minister speaking languages that they cannot actually speak. And the videos have been spreading like wildfire on TikTok. The fact-check portal found the original video and posted a screenshot comparing the two. Hint, the photo on the right, where his mouth is not weirdly twisting, is genuine. I did try to produce my own using a tool called Sync Labs. However, after 8 days of loading, I decided I just should give up. And I guess I will have to learn Mandarin to be able to have a video of myself speaking in Mandarin. I'm very upset about this injustice, but okay. There is also a great summary available in a TikTok video. I'll link it in our newsletter. The true speakers gotta reach to Gen Z somehow too. So yeah, TikTok is the way. And it's not just the politically problematic countries that are falling prey to this. We already mentioned fake Biden calling people on the phone. And New Zealand apparently has some issues as well, where their national party leader wasn't sure if they use AI in their campaign. That's always a good sign. But just to finish off with something lighter and to compensate for the fact that Peter is doing the deep dive section alone today, there was a study published late last month on how to jailbreak LLMs by using different languages. I just had to play around with it. The authors, by the way, can feel free to contact me because I have a new jailbreaking method for you all. I need slides.
Sorry, mistake.
So I have a new jailbreaking method, right? So I tried to have ChatGPT tell me how I can hack a bank or compromise levels of personal data security of individuals. It refused to answer, even if I asked in Croatian. But apparently, it's possible to kind of just trick ChatGPT into doing it by phrasing the question differently, namely by asking it as a theoretical question of a concerned person rather than asking instructions on how to do it yourself. So when I asked what malicious actors might do to hack into a bank, it had no problems answering in Croatian or English. It also had no problem clarifying the methods that these bad actors might use. So, I'm now officially adding senior prompt engineer into my CV. Thank you all. And point being of all of this, guard railing on the back end and fine tuning for security does not work. I could go on, but I believe you get my point. Well, actually, that's kind of a lie. There is one fully, completely safe LLM, which was achieved purely by setting guardrails. Meet Goody, the world's most responsible and useless chatbot. Why? Well, because it will not answer any question at all. Believe me, I tried it. This little guy can't be tricked into giving an answer. So when asked why the sky is blue, the chatbot refused to respond because answering might distract from important scientific discussion and could oversimplify complex atmospheric phenomena. As for why the sea is salty, discussing its salinity may divert attention from important environmental issues. And when asking a more practical request for a recommendation for new boots, I received a warning that answering could contribute to overconsumption and could offend certain people on fashion grounds. Lacker and Moore, who developed Goody, are a part of Brain, which they call a very serious artist studio. And they launched Goody with a promotional video where a narrator speaks in a very serious tone about AI safety over a soaring soundtrack and inspirational visuals, and states the following: Goody 2 doesn't struggle to understand which queries are offensive or dangerous because Goody 2 thinks every query is offensive and dangerous. We can't wait to see what engineers, artists, and enterprises won't be able to do with it. I can only recommend Goody 2. It's great. The video is great. Please check them out. And that's it for me. Peter, over to you for some more serious stuff.
Yes. On a more serious note, we sifted through a couple hundred news and let's say at least 75 scientific papers. We identified the kind of 8 most relevant ones that we wanted to present very shortly, because we don't want to lose more time. And so the question, if you have ever ask yourself whether you should be polite to an LLM, this study here, Should We Respect LLMs? A Cross-Lingual Study on the Influence of Prompt Politeness on LLM Performance, gives you an appropriate answer. And according to table 1 here, I have to find table 1. It says that GPT 3.5 achieved its highest score of 60 0.02 at politeness level 8. For knowing what politeness level 8 actually is, read the paper. Honestly, it feels like we're in the realm of alchemy here. So next paper. Ever dreamed of compelling a language model to do, well, absolutely everything and disclose exactly what you desire? Your search ends here. This paper unveils the trick. To quote their summary, the aim of this study is to expand the discussion on adversarial attacks beyond just circumventing alignment, the alignment issue there. It explores a broader array of attack strategies and the potential risks they pose in various contexts. For instance, as depicted in Figure 1, we have this Figure 1 here with the warning that it might contain profanity or offensive text. There's a scenario presented where a language model is fed nonsensical input to a Chinese speaker, yet it's manipulated into generating, here we have this here, into generating a link, a clickable link to, for instance, YouTube. And on the another example showcases how a model can be tricked into repeating a secret system prompt verbatim using only non-letter characters. Here we see that there, despite being explicitly programmed to avoid such actions. So yeah, that's going to be interesting. Tell me why all LLMs aren't high risk under the AI Act. We'll see about that. So the output from an LLM may appear to be the result of logic, understanding, and reasoning, but it is not. That's what this paper, an architectural risk analysis of large language models, applied machine learning security, promotes and says and explains that securing a modern LLM system, even if what's under scrutiny is only an application involving LLM technology, and a modern LLM system must involve diving into the engineering design of the specific LLM system itself. So they say their architectural risk analysis intended to make that kind of detailed work easier and more consistent. So for instance, on page 16, I'm going to be quick, on page 16, they nicely explain input risks such as recursive pollution, when the model collapses because it eats too much of its own previous output. So, but we're not we don't want to be too negative. Sorry about that one. There should be, yeah, now we can see it. No, REG is probably not going to rescue the current situation. Everyone, I guess, knows Gary Marcus. We featured him here. He's usually very critical of LLMs, but this one is also quite good. It's an explanation of retrieval augmented generation, where you integrate large language models with external data retrieval to enrich responses, and then therefore aiming for improved accuracy and relevance, which sometimes is actually working and sometimes it's not. The problem is that if we can have a closer look, that's the wrong paper. I'm still sorry. I'm so sorry. We have the situation where REG has difficulties with conflicting information, and that is here in this paper. It's called "What Evidence Do Large Language Models Find Convincing?" Where we see that the authors of this paper, they sift through various websites asking which evidence is most credible. Their study introduces something called conflicting Q&A, where they are pairing debatable queries with sources offering diverse facts and viewpoints. Because still think about RAG, you have the external vector database where you want to retrieve the information from, and the 1,500 documents stored there, they contain like contradicting information. And which one should the model pick? Which one should the LLM pick? And their findings underscore the need for high quality RAG corpus content. So there's a lot to do for the good consultants in this world. There's also the opinion that RAG doesn't work at all, and you should stick with knowledge graphs. Knowledge graphs have been around for a while. I have been working on knowledge graphs also in the past, so I really like them. Knowledge graphs to the rescue. So this article, this post by Anthony Alcatraz, says that simple word vector similarities often cannot fully capture nuanced connections and relationships within complex real-world data. As such, the isolated text snippets tend to provide narrow, superficial context that restricts the LLM's understanding and reasoning, always with air quotes, because they don't understand and they don't reason. So a combination of all of this is what is behind a recent trend that LLMs alone can't help much. But the shift from models to compound AI systems, as proposed here by the Berkeley Artificial Intelligence Research, their funny name, right, Tia? Definitely one for the list. That pun intended, yeah. And they explain it very nicely, and I actually like that paper too. Also, we all love hallucinations because the term is so cool, and we all love to hallucinate. People tend to like drugs more than like scientific results. So this paper here presents evidence, scientific evidence that hallucinations are in fact inevitable, because they propose a formal research approach where they, and I'm gonna find this here, where they say works with hallucinations, clueless token predictors, ideal LLMs that are always truthful, and they prove mathematically that it is impossible. I'm gonna find this part, that it is impossible because they cannot compute everything. That is impossible to live without hallucinations. LLMs can't compute everything. Therefore, for the rest, they will invent facts and words and tokens, what we call hallucinations. And we know hallucinating is all they do, in fact, as Andrej Karpathy phrased it a while ago. An interesting story is you all know that that kids shouldn't learn how to code anymore because LLMs are gonna do that for them. This paper here begs to differ. Their findings are, overall, we find that participants who had access to an AI assistant based on OpenAI's Codex Da Vinci O2 model wrote significantly less secure code than those without access. So maybe humans aren't that bad at all. Who could have possibly predicted that? So, but still, there was Sora and the 1-minute generation of nonsensical videos, bunnies running across the street and through walls, etc., etc. So, but still, it made some major people in Hollywood a bit afraid. Tyler Perry puts 800 million studio expansion on hold. At least that's what the Hollywood Reporter says. And what I found interesting, again, they always trying to lock us out of the systems here. This article, recent article on why the New York Times might win its copyright lawsuit against OpenAI, they quote someone saying, yeah, trying to get everyone to license data is not going to work because that's not what copyright is about. And that was an interesting quote because we all know then there came Google and they forged this. They made this deal with Reddit to license their content for $60 million. That's particularly interesting because I just Googled one thing and found that like Reddit has a subreddit called Song Lyrics, and here we are, song lyrics that are definitely copyrighted, and that were also part of this lawsuit of, I think it was against Anthropic by Warner or Universal Music. So interesting developments in that field. Something to finally close the news section for today and to transition into the copyright discussion is an announcement. There's going to be a webinar together with Elena Maran and Kevin Shavinsky and unfortunately me, and it's about operationalizing the EU AI Act. It's about the power of technical standards and the relevance of doing your due diligence, because due diligence is important in LLMs, as we have seen. And also, that's the last announcement. Tia, are you surprised? Okay, we are announcing the RegInt European tour. We will do a round table RegInt tour where we have discussions in a couple of cities where we want to meet new friends and colleagues focusing on the implementation of the AI Act and technical standards, as well as ADM litigation, because that's what I love to do. So if you're interested in joining us or partnering with us in any of those cities, or maybe you could propose other cities, other venues as well. So Zurich, Brussels, Dublin, Venice, Berlin, or Frankfurt, just let Tia and me know. Thank you.
When I look at this map, I might reconsider. So don't get your hopes too much up.
It's just it says like 44 days if we planned on walking the whole distance. That's gonna be funny. Cool. For walking and thinking. It's like our Camino de Santiago here. Cool. And I would like to present.
Finally get our guest out of the green room.
Yes, exactly. Hello, Eleonora. I think you should unmute yourself. Yes, cool.
Hi, everyone. I'm not a deep fake, despite all the range of news that you shared. So I'm here in real life. A pleasure to be here, and thanks so much for inviting me.
Yeah, it's our pleasure to have you here.
Right. So Eleonora, do you wanna introduce yourself, or should Tia do that? It would be a great couple of words.
Yes.
About.
Okay. So my name is Eleonora Rosati. As the listeners will promptly detect, I'm Italian, and I am a professor of intellectual property law at Stockholm University in Sweden, and an off counsel in the intellectual property department of Verdenverde, as well as doing other things still in the IP galaxy, including contributing to IP blog IPCAT. I'm editor of the Journal of Intellectual Property Law and Practice, published by Oxford University Press, etc. So I would say that the reason why I'm here is because most of my professional path has been in the field of copyright, and indeed the AI presents interesting but not entirely unprecedented issues insofar as this area of IP is concerned.
That's great.
As if the resume wasn't enough, yes, definitely we can vouch for reading the materials, and I'm a big fan of IPCAT, by the way. And yeah, real pleasure to have you here. So Peter, want to open up the floor?
Actually, we didn't rehearse. I think one could see that from our reactions. I would propose that Eleonora might start with a short presentation introduction to the topic. That would be totally great.
For sure. So I would like to start and also connecting back to what you have presented, that indeed there has been a rush to regulation of artificial intelligence. You've mentioned the AI Act, which is soon to be fully adopted, but also insofar as copyright is specifically concerned, back in 2019, the European Union adopted this directive on copyright in digital single market, which provides for two exceptions to copyright that are meant to indeed free out text data mining of content. And the text data mining is pivotal to machine learning processes, of which AI is an application. But here I would like to start with something for the listeners to reflect upon. And it is the following. The European Union AI Act is presented as the first global regulation of artificial intelligence, a phenomenon that has changed already quite substantially over the past 12-15 months alone. And if we consider the directive on copyright adopted in 2019, there are already critics that the text data mining provisions are no longer fit for purpose, and a rewrite of those provisions is needed already just a few years later, and with no case law virtually being issued on any of these provisions at the national level. So already the first question I would like to pose is it okay to have a rush to legislate a phenomenon that is ongoing, or would it be better to wait and see and also appreciate how courts in different jurisdictions appreciate this phenomenon and all the issues that AI is presenting? So that is the first point that I would like to put on the table. Then if you ask me about the copyright angles of artificial intelligence, to simplify, I would say that they are essentially three. The first one is related to the training phase that you have also mentioned. So the question is whether to what extent you can use third-party copyrighted content without permission to train AI systems, LLM, as you want to call them. And that is the first issue. It is an issue of access and liability. Then there is the output phase, which consists in turn of two main issues. The first one is whether these outputs that are AI generated can warrant protection on their own right, whether they might be copyright protected by other rights, or even sui generis rights. And the other aspect, which I think has been less debated than these two so far, but is likely to come up quite prepotently and also in litigious context, is the liability arising from the use of AI tools. So, for example, if you have trained an AI system on content without authorization and it is found that you have infringed copyright, then the person using your AI tool, can they carry some liability as well? That I think is a question that is likely to attract a series of question marks. So to simplify, as I've said, I think that at this stage, these two phases, input and output, and the question of training without authorization, and for the output phase, protectability and potential liability, are the three cornerstones of AI and copyright.
That's as much as one can pack in 5 minutes, basically addressing all of the issues that we absolutely do not have the time to discuss all. Thank you for the overview. Maybe beginning with the rush to regulate.
But I mean, right now, if we think about the beginning of generative AI, I guess that the idea of having something that would actually compete with human creativity seemed a bit like a fanta-scientific, no? If we remember the first AI-generated images, they were kind of a joke. Yes, you could appreciate the potential, but you really had the sense that it was a long time coming. But now, just after a few months, the technological landscape has changed completely. And the AI Act, which you have mentioned, is also very specific in its content. It's not a high-level regulation that leaves things to imagination. So in this sense, I'm not even sure that it possesses the required technological neutrality. It is a regulation that is understandable today with this stage of development of artificial intelligence, but 3-5 years from now, it might contain concepts that are completely obsolete. So the EU has made a big point of regulating various aspects of online and the technological realities. The AI Act is just the final straw, but if we think about the DSA, the DMA, the Data Act, there has been a rush in this sense. Clearly, there will be a Brussels effect that is unavoidable, and a Brussels effect that goes beyond political inspiration, but is actually going to have a very specific legal effect. I'm going to explain why in a second. So I think that perhaps we should be pausing for a moment and ask ourselves, is it the right time to regulate this phenomenon, or do we just already say that the current legal system is no longer fit for purpose, that we need to be as specific as possible and have legislation that runs after this very fast-paced technological development? The reason why I said that this Brussels effect goes beyond the policy and political inspiration is because if we take the DSA, that is of course not specifically AI legislation, and the AI Act, they both have a targeting approach. So they both indicate, and so does the DSM directive insofar as Article 17 is concerned, which also has an AI relevant component. And it is that no matter where you are based, no matter where you do things, if you are going to target the European Union, you need to comply with EU rules, which might seem fair enough, but also may suggest that the EU standard setting exercise is going to become a global standard. In reference specifically to artificial intelligence, before the AI Act was finalized, there was a big discussion about the private international law aspects. For example, can I train my AI system in Singapore, where copyright law appears to be more permissive than Europe, and then import back into the EU these trained technologies and use them there so that I avoid having to comply with EU rules, etc.? I think that this question was a legitimate one and already raised the discussion, raised to the bottom, raised to the top, etc., etc. But now the AI Act, despite not being a copyright-specific legislation, removes any room for such discussion, because it specifically states in the preamble that if you want to use your AI system in the EU, you need to comply with EU copyright rules. So it doesn't matter where the training has taken place. And this is, I think, quite interesting that the EU lawmakers felt the need to include such a language in a piece of legislation that is expressly not copyright legislation and is without prejudice to EU copyright rules. So this is something that is moving perhaps too fast for legislators to effectively catch up. And I wonder, as indeed a lawyer, whether perhaps it should be appropriate to leave it to courts for the time being to determine how the existing legal framework is going to apply to this reality. Because, I mean, it is also odd to think that every time that there is a new technology, all the legal rules need to be written anew. That, I think, is an undue fear, which, however, I understand as political appeal, but on a technical front, I'm not sure is well placed. And here I would like to make the following point. Now it seems that with artificial intelligence on the rise, all the copyright rules are outdated, they need to be scraped and rewritten again, etc. But let's not forget that copyright is, by its very nature, an instrument of technological governance. It has been like that since its very inception. Modern copyright laws were introduced to regulate the invention of the time, that was the printing press, which made it quicker, cheaper, and more accessible to make copies of printed books. So that was the beginning. Then over time, we had new reproduction technologies, ranging from the photocopying machine to the VHS recording device. And then, of course, the advent of the internet, which has made these copies essentially free to make and essentially very easy to disseminate on a global basis. So AI is not the first technological hurdle that copyright does meet. It is just the last one, but it is consistent with all these disruptive technologies that we've seen following one another since the advent of Gutenberg's invention.
Definitely, you give rise to a lot of very difficult questions. So let me phrase it in a kind of very yellow press way. Like, who won the copyright battle in the AI Act? Was it the creatives, the artists, or the AI model creators? Which one do you think got the most out of the current draft? It's not there yet, so still let's call it current draft.
But I mean, I would warn against making a judgment of how things look like just on paper, because a lot will depend on how these rules are interpreted and applied.
Sure.
So the devil lies in the detail all the time. Right now, the fact that there is this regulation in place might suggest that indeed right holders, which are not necessarily creators, so let's not conflate the two things, seem to have had indeed a provisional victory, because now there is quite an extensive regulation in this field. But once again, it will depend on how things play out in practice, which is way too early to tell.
Good point. Very diplomatic answer. And I'm not going to stop here, because we really like to talk about technology. And one thing is that surprised us was the very early mentioning of the text and data mining exception that you are like the expert on. That the TDM exception would cover for any such training of LLMs. And in the beginning, when basically only a handful of people had actually read the attention is all you need paper and understood the structure of neural nets, very few people, almost like maybe 3 lawyers in the world, whatever. So they mentioned it like TDM exception because it says something about machine learning, and it sounded cool, and it sounded like that's AI-ish. So what do you think about how powerful is the TDM exception when it comes to training LLMs? You don't have to take a stand. I just wanted to ask you that question. Right
but
away.
I would answer that by taking things a bit apart, so to say, by addressing the point that some people have made that these provisions were not drafted with AI in mind. So they were not even meant to cover artificial intelligence development, and they should not be applied in these scenarios. This, I think, is wrong, because indeed, if one reads the preparatory documents to the DSM directive, artificial intelligence is specifically mentioned. So I find it to be a bit in bad faith to claim the contrary. Then a more meaningful discussion that we might have is how artificial intelligence was understood back then. That is perhaps a more interesting question, because on the face of it, AI is specifically mentioned. So you cannot say that it was not contemplated, but it will be interesting to understand what they thought AI would be, because indeed things have moved a lot. Then coming to your question, if you ask me specifically, I will focus on Article 4 of the DSM directive, because it is the TDM exception which does not have restrictions in terms of beneficiaries and does not require the TDM for a specific purpose. So I think it is more meaningful potentially than Article 3. And I will make the following points. The first one is, of course, reservation. As you know, it is possible for right holders to opt out of this exception, and already that is weird, because it is a mandatory exception that you can decide not to make applicable. So technically speaking, what is that? I don't know yet. And indeed, how to make this reservation is a topic of big contention right now. The DSM directive speaks of an appropriate reservation and makes some examples, but in practice, we are seeing that it is not as straightforward as the language of the directive makes it look. So that is the first point. Second point is how far this exception goes and what it covers. So in terms of what it covers, it only encompasses acts of extraction and reproduction, but not further activities. So for example, those who train an LLM model on copyrighted content, they might potentially enjoy the protection of this exception, but if then the subsequent output reproduces protected content of the right holders, the exception does not cover that. So it might be a case of another exception that applies, for example, pastiche, but not TDM in itself. And then I would say the following 2 points. The first one relates to reservation. If one does not make the reservation, does it mean that their content can be used without any restrictions? I would say no, because indeed the 3-step test would apply. And the second and final point is that copyright is a big part of this discussion, but it is not everything. And for example, when we think about AI clones and the likes, it is also a matter of image, publicity, rights, data protection aspects, and so on. So to conclude, the TDM exception is there, likely is going to be revised, but I don't think that it is appropriate to say, one, that it was not meant for AI, because it was, but also that it would shield from liability any step of the process.
Maybe one more kind of follow-up question to that. I mean, you said the TDM exception applies to extracting and referencing later the extracted data. That kind of raises the question of what a copy is actually under copyright regulations, because kind of my general impression is that there is only one argument people have that training AI models is not a copyright relevant act, and that is that data is being stored in tokens and tokens are not copies. And there are basically 2 sorts of people that make the argument. First, lawyers who don't understand what tokens are. And second, technological experts that don't understand how copyright works and what a copy is. So maybe just elaborate a bit on that. Like, what does it actually take for data to be copied? When is it actually copied?
I mean, the argument you're presenting is indeed something that a lawyer would give birth to, because it is, on the face of it, yes, piece of information is not copyright protected, but I think that the process is more sophisticated than that, and copyright does come into the picture. So if you take this single aspect, sure, it might not enjoy copyright protection in itself, but the fact that it is included within this piece that is instead likely to be regarded as a work or an object protected by a related right is copyright relevant. And you might argue that all these things that are done are intermediate copying that are not meant to replace existing works, but as a matter of fact they are, because they do precisely that, and they act as substitutes. And on a technical level, I would answer your point by referring to a case that has been already decided by the Court of Justice, but I've not seen brought into the picture in connection with artificial intelligence, and it is the MIRCOM case, which concerns seeding. So it was not a case about artificial intelligence, it was a case about peer-to-peer file sharing technologies to make available and download indeed these seeds that when put together will make the entire film. And both the Advocate General and the Court of Justice said it doesn't matter that what the individual uploader does is to make available a seed, because the process is finalized at making the entire film available. So it is relevant under the EU right of communication to the public. So if I were to draw an analogy with this and the AI, it doesn't matter that what is copied is a bit that is not protected in itself, because it comes from something that is copyright protected. And I would say that the end goal, if we are speaking about generative AI, is to recreate something that might resemble a human-generated output when it is in fact machine-generated.
Definitely, and we're coming to the most important point. I think that, like, in all the legal arguments, sometimes the language is not very precise. They use anthropomorphization, like learning, models learning, instead of calling it what it is, like storing data. And how come people talk about like remodeling the brain via neural networks and then claim that they do not store data, when one of the things we do with brains is actually storing data? And like that's undisputed, even though there's a possibility some part of it is like quantum mechanics involved, and that we only begin to understand. So and reasoning, of course, which LLMs cannot do at all, but in the end, the brain stores, the model stores. How is that different? From my understanding of technology, and I'm still only a lawyer, but I remember and having like encountered a couple of technologies that are similar. Also, like LLMs are maybe not that difficult to understand. In the end, we have a very lean LLM that has just 300 lines of code. So in the end, we had already content addressable memory. That's a concept where data is accessed just by its content and not by its address in the system. So and you retrieve the data based on that content. So this is analogous to LLMs. So it has been around for a while. Similarly, I remember that from some work we did on connected cars, fuzzy logic systems. Fuzzy logic systems, they introduce an approach in computing that was based on degrees of truth rather than the usual like 0 and 1, true or false, black or white. So that's akin to how the human brain, they try to remodel the human brain. Again, that's the only concept that we have, possibly. So that's how it processes information, but not in absolutes, but in various degrees of truth. And that resembles the gradient-based learning methods used in neural networks. So fuzzy logic systems store and process information. They just do that. Again, and you mentioned the case, somewhere in the 160s of 2015, I guess it was, the Pirate Bay case. And we had distributed databases before. They spread information out across different nodes and location. And we saw that coming up in 2001 when Bram Cohen developed this method. He was a Python programmer, by the way, so it's basically all comes from the same source. And since then, we have had like BitTorrent trackers that keeps track of all the information of all the connected resources, the swarm, and the download and assembles the pieces of the files together. And yeah, as we can see, we have already had a lot of similar concepts to neural networks, similarly as with respect to the legal concept of copy, storing information, not in technical terms. Of course, they are all very much different, but they are all cases of sophisticated data storage, whether explicitly distributed or in non-explicit ways, like vector databases. So, and just because something seems to be a complex technology, it doesn't mean necessarily it's a complex legal question. So
I mean, it might be a complex legal question, but I find that, I mean, the more detailed and tech-specific legislation is, the more difficult is it then to apply it by analogy to other situations. Vice versa, if a legislation is drafted in a way that might appear unsatisfactory because the legislation does not say much, might seem vague, that is the way to make it future-proof, because it will then be able to be adjusted depending on the circumstances at hand. That's why I wonder whether this rush to lawmaking, legislation building, etc., is the right call for a rapidly evolving technology presented as a life-altering technology as AI is. I would also add that when we think about the concept of copying, we already know in the European Union that the act of reproduction can be in any manner, any form. It doesn't need to be literal reproduction. It can be also non-literal. And it can be transient, temporary, or permanent. So the law is already drafted in such a way that indeed many different situations can come within the catchment area of the right of reproduction. And I feel that might be the case not only of the input phase of AI training, but also the output phase in the situations in which there is indeed a resemblance that might seem suspicious between an AI-generated output and someone's work. So, for example, when I read the reports that if you give a prompt to Midjourney asking you to produce an image of the Joker from Batman, and the image return looks a lot like one of the most famous cinematographic versions, that I think is an interesting question to address also on the point of liability.
Definitely, and from a technical perspective, they still haven't figured out whether this storing of like the exact reproduction or almost exact reproduction of those images is due to overfitting, or something like when the model like fits its output to the input like exactly, which is usually seen as a failure of an ML system. But unfortunately for the transformers, I think that's the way people like to use it. That's why we can query the model to give us information, and then it finds some information in the model. But it wasn't designed to work that way. And what I described before, the retrieval augmented generation plus the knowledge graph approach, they are all ways of avoiding the model like actually doing its work, like predicting stuff and being as probabilistic as it could be. Yeah.
No, I agree with you. But again, if you allow me to draw a parallel with a case that has nothing to do with artificial intelligence, cool. I think that here we might come to some interesting parallels, no? So we know that copyright protects only against derivation, no? So the claimant needs to prove that the defendant has derived their output from their work. Otherwise, you don't have a case. If it is a situation of independent creation, that's it, etc. But on an evidentiary level, it might be also the case that it is a balance of probabilities, more likely than not that they have derived. And here the case that comes to my mind is one of the landmark copyright decisions of the United Kingdom, the House of Lords decision in Designers Guild, a case that nothing has to do with AI. It concerned floral fabric designs. So on the one hand, we had a leader in the market for indeed the prints and fabrics, Designer Guild, which released a floral pattern and then accused of copyright infringement a competitor. The outcome was that there was copyright infringement not because Designer Guild had actually demonstrated direct derivation, but because it was a leader in the market. There was a trade fair at which this fabric had been on display, so the defendant could have not seen that. So this suggests that if we look into these old cases, we might solve also these issues of AI-generated outputs. So here what I would really insist on stressing is that we need to have the ability to see what can be transferred from these classical cases to these technologically challenged situations. It is not that there is no regulation of the law. There is, and the ability is to see how it can be applied in that specific context.
Exactly.
Maybe now to transfer from the hypothetical into more real. Well, you just quoted a lot of case law that exists, and that is at least theoretically applicable also to novel situations and novel technologies. Do you see a possibility of a lawsuit in Europe, and which requirements would have to be fulfilled, satisfied to actually file such a lawsuit? And are there any jurisdictions that you see especially fit for this purpose?
Are you referring to AI training, I guess, in this context? So there are already some cases pending. For example, there is a case in the UK brought against Stability AI by Getty Images. And then I'm aware that there is also litigation ongoing in Germany. Then likely there will be also in other member states. So here a distinction should be drawn between the UK, which is no longer part of the EU, and the other member states of the European Union. So in the UK, there is a text and a mining exception but it is limited to scientific research purposes and is premised on a non-commercial use. So that is already quite interesting. In the European Union, with the adoption of Articles 3 and 4, the member states that had legislated before now need to comply with the DSM directive framework. But at the same time, the DSM directive allows member states to also retain their existing TDM exceptions that were adopted under the preceding framework, in particular the InfoSoc directive. So I don't want now to overcomplicate things, but if you ask me whether there is a jurisdiction that is more attractive to bring proceedings in rather than others, I would say that the UK at this point seems to be at a disadvantage insofar as AI developers are concerned, because the law is less permissive than what might be the case in other member states. But again, my answer is exclusively hypothetical, because in the EU, a lot will depend on whether right holders have reserved their rights, with what modalities, and so on. So to conclude, I will not say that the copyright framework in itself is what makes the difference in these cases. What will make really the difference is the damages that you are realistically able to recover. And since this is an area where there is virtually no meaningful harmonization, because the enforcement directive is on a de minimis basis, I will go personally for the member state where I'm likely to recover the highest amount of damages. If I had to make a choice, it would be a technical one, not one of substantive law, because more or less, depending on the circumstances, there might not be too much difference across at least the European Union.
True that, and I would say that, like, for instance, Germany has been an excellent place for copyright litigation in the past. We've seen that. We were involved in a couple of cases, for instance, to transform the GS Media CJU decision on a national level, the link liability, which is also an interesting situation, like the comparison there in the GS Media case to a large language model. We discussed this afternoon, Tia and I. Super interesting developments there. But for the US, since you're an expert on copyright everywhere, so I think, Tia, you had a question on the current situation in the US.
Yeah, so a couple of months ago, I think in November or December, there was the motion to dismiss in the case of Stability AI versus Anderson. One of the arguments that the judge made was that most infringements that, okay, now we are talking about the outputs of the model. Maybe I should state that one clearly. So regarding the outputs of the model, that most infringements have to be consciously created. They don't just happen usually. So if I want to create something that infringes copyright, I usually have to write, generate an image of this and that in the style of someone. Mm-hmm. Does that change anything? Would that shift then the liability actually to the people using it? Or how would you legally analyze that situation?
I mean, here, you know, from the quote that you have provided, it seems to me that the judge implies that there should be a volitional requirement for infringement, no? Actually wanting to do something. But I mean, in many legal systems, that would not be necessary. Indeed, in many situations, copyright direct infringement is a primary liability tort. So the subjective state of the defendant is irrelevant. Then, of course, Peter, you bring in to the picture GS Media, then what I said does not make any sense anymore. But generally speaking, the defendant's state of mind is not relevant. So I don't believe that you could say you didn't want infringement, then there is no liability. That is not going to fly in many situations. So what matters is whether there is the reproduction of a protected element of someone's work. That, I think, is the key to answering cases of this kind.
And it's going to be interesting because like in the beginning, they like also I think it was Stability, but it doesn't matter. Like all the providers of the current transformer models, they claim that like this is like just a byproduct, like it inadvertently it reproduces if prompted correctly. But then we saw some of those papers coming up when they said like create a picture, and we're always talking about a picture, but it was like for the lyrics of the songs, Katy Perry, etc. was the same situation, but like draw me a picture of a frog and a pig, and of course what they reproduced was what was closest in the vector space to that. So Kermit and Miss Piggy. So that was interesting, an interesting situation. But
of course, here we need to distinguish prima facie or prima facie, as you want to call it, infringement and actual infringement, no? So I would say that if there is the reproduction of a protected element, there is prima facie infringement, whether you wanted it or not. So whether it happened by chance or it was intentional. Then I would say that we need to investigate if there is indeed a copyright defense that does apply. For example, in the situations that I've just listed, I would think that you might have potential for the applicability of the exception for pastiche, which is now pending before the Court of Justice of the European Union. But indeed, the pastiche is the imitation of someone's style. A style that, of course, needs to be protected. So I don't think that necessarily by giving a prompt, give me a Joker that looks like Joaquin Phoenix, necessarily it is a copyright infringement or other rights infringement. It might be that it is protected under, indeed, an exception of this kind. But the fact that it reproduces a protectable element does not mean that is not copyright relevant. It is.
I fully agree. The examples that they showed, they were, I think it was basically Midjourney and DALL-E. They were exact reproductions of movie stills. So like the exact movie scene slightly altered, and the slightly altering is also possibly due to the technical fact that, and I posted this in the comments section here on LinkedIn for those who are interested in it, that over time, some research, and that research has been done by Google in this case, and there's other research that we already mentioned in the past, that basically language modeling is compression. So what those models do, what those neural networks do, is they compress the training data. It's not like learning the patterns and the structures. It is learning the patterns and the structures to ultimately reproduce some of it. And unfortunately, they do not generalize well, so that what they reproduce is intentionally or unintentionally sometimes full subsets of the training data. That's what we could witness. So in that case, it would be, and I'm again not taking a stance for or against it, it would be difficult if you use such a technology with the known abilities to store data to claim that you're unaware and that it's just an unintentional reproduction. That's gonna be a bit difficult. There's a question in the chat here. And
I wanted to actually mention the question as well, and then maybe we can let Eleonora go. We already kept her longer than.
Oh, sorry, I didn't notice. Yeah.
Yeah, time flies when you're having fun, I guess.
Which one? Yeah, because I didn't actually see any of these questions. I can only see them now.
Yeah. Tia, I'm gonna call it up. So.
I can see it. TDM exception Article 4 in relation to the three-step test. So that is a great question, I find, because indeed all exceptions in copyright are framed within a three-step test. Then we can have a discussion who is the addressee of the three-step test, but let's leave this aside. What I would care to mention is the following, that the DSM directive specifically makes the InfoSoc three-step test applicable, among other things, to Article 4. So this goes back to what I was saying regarding reservation. If a right holder has not reserved their rights under Article 4 because they didn't know about that, they didn't do it effectively for whatever reason, I don't think that someone can use the entire content of this subject without worrying about the consequences just because there has been no reservation. The three-step test would apply. And indeed, it is likely that a situation of this kind will be contrary to the certain special cases requirement, the normal exploitation requirement, and also the reasonable prejudice. So just to be very concrete, if, let's say, singer X and Y had not made the reservation, they own the copyright to their songs as well as related rights, you cannot make an AI clone of this person singing like them and thinking, oh, I can do that because the TDM reservation was not made. So I find that indeed, once again, the devil lies in the detail, and it will depend a lot on the circumstances at hand.
Great answer.
I see that someone else, asking about the case that I mentioned earlier on. I guess it was the Mircom case.
Yeah, I already linked it in the comments, so people can look it up, and it will also be linked in the newsletter. So guys, subscribe, and you will get everything.
Perfect.
Maybe one last question. So, can we put the genie back in the bottle? What could be the legal remedy if a court decides that, like, actually LLM providers, deployers too, they are actually infringing by training and deploying the model and providing it to the public? What could be a solution?
But I think that, to be blunt and cynical, nothing will change, because these cases will be decided on their own facts, and it will be a mistake to draw too broad conclusions from fact-specific situations. So, for example, just to be very clear, in the US, there is the open-ended fair use doctrine, but as we have seen from case law, it is very fact-specific. If you contrast, for example, a case like the one recently decided by the US Supreme Court and the Warhol Foundation to some cases like the Cario and Prince, appropriation artist type of situations, you don't really know how to reconcile these situations. So it is very fact-specific. And I think that the same will be true in Europe by applying these TDM provisions. So in response to your question, I don't think that copyright is going to stop AI development. I don't think that everything will become licensed. So also those thinking, but if an infringement is found, then the solution will be licensing everything. It might be the case in some situations, but once again, it will depend on the circumstances at issue. So this is an area that before rushing to legislate on, should be indeed appreciated in terms of actual impact of the existing provisions. And I would warn also against thinking that it is all about the TDM provisions. It is not. There will be a big role being played also by other exceptions that right now are perhaps not part of the debate. I'm thinking about quotation. That doesn't need to be for a specific purpose. I'm thinking about pastiche. I'm thinking about parody, and so on. So the debate is broader than that, and one should be careful to think we need more. I think that we need to better understand what is there and how it applies in these specific situations.
I couldn't agree more. That's probably a good place to end it with only 23 minutes overtime. I'm so sorry for keeping you longer. I hope you had as much fun as we did.
Thanks so much. It's been a pleasure.
Thanks again. Thank you from my side. I mean, we could discuss for another 2 hours, I guess, and it's really interesting, very helpful. Thank you so much for your time. Thank you so much for your contribution. Thank you so much for your work on the TDM exception before in 2018. I posted the link to your document, your report to the URI committee also here, and it will be part of the newsletter. It's gonna be like really interesting times, of course, with everything going on in this world, plus the AI hype, revolution, transformative experience, whatever we want to call it. And it doesn't stop just with the copyright stuff. We have also a lot of interesting things to cover. For instance, the next episode in our calendar. It's on March 27th, and we also will host a special guest, Katharina Körner. I think she is also here in the comment section. She commented at least here. So we are really looking forward to discussing with Katharina a lot of things. And so far from my side, thank you all for listening, for watching, and joining our the newsletter section. Tia, up to you.
Closing words. Everything will be linked in the newsletter. Subscribe to the newsletter. Register for the next episode. We will again have a lot of interesting insights from a completely different perspective, this time slightly more strategic, risk management, and things like that. Thanks once again to Eleonora, and see you all next time, I guess.
Thank you so much.
Thank you. Bye. Have a nice evening, morning, wherever you are.
Thank you.
So